Alrighty, folks, looks like we are live. I'm George, one of the founders of Solo Suit, helping you guys out here tonight. Gonna be giving some good tips on how to win your debt collection lawsuit. Let's just make sure the audio and the visual are all working good. Let me know if there's any problems in this. So I'm just gonna go over some of the basics on how to respond to your debt lawsuit. I'm with Solo Suit, you know that because we got the sign back over here. Also got my hat on tonight, so that's good. We are going to give you some of these basic tips, just go over some of the basics, and then we're going to get into your questions. If you have any questions, go ahead and put those into the chat, and then hopefully we'll have some answers for you. Before we get going, just a quick disclaimer, I'm not a lawyer, I'm not your lawyer, so this is not a law firm, we aren't providing legal advice, this is just a webinar. Those are some things we say just because of regulations. So I just wanted to put all of that out there already. So I'll be responding to questions verbally. We also have wonderful assistant Hannah who will be responding to your questions in the chat as well. So go ahead and be looking for those responses. Alrighty, jumping into it. Here is our website. You've probably seen it by now. If you want to respond to a debt lawsuit, which is what most people want to do, most people on this webinar have been served a lawsuit, they've been sued for debt. If that's your position, you can just come onto our website, click reply to a debt lawsuit. This is our debt answer tool. You can see we have a 4.7 star rating out of 5 stars. That's real good. Also been featured in Fast Company, NPR, and TechCrunch, as well as ABC. You'll be able to choose one of these two packages. Our premium package is $247. Our standard package is $67. $67, you'll get the answer document generated. You'll be able to download that as a PDF. We also calculate the filing fee. About 25% of states in the U.S. charge a filing fee to file this document in court, unfortunately. And then we'll get that document filed. We usually file this document by mail. Most courts require a document to be mailed into a P.O. box to be filed. Only mailer that can mail to a P.O. box is the USPS, so you can't do it over FedEx or UPS or something like that. So we're using USPS. Standard goes by USPS certified 3 to 5 day mail, and then we'll give you status updates, but it's basically like emails along the way as that document's getting filed. For the premium package, it's pretty much the same idea, but much more valuable in a number of ways. One, the document filing's faster, so we're filing that over 2 to 3 day USPS priority mail, which also has a better tracking system. And then it has the attorney review. So an attorney will do a written review of your answer and complaint and summons, making sure that things are good to go, that you input information appropriately on the website. All right, so that's the quick rundown on those products. You can also check out our reviews, see how people love us. We got Ortiza left us a review. Helpful, triple exclamation point. We got a review from Bruce Norvell. As you can probably understand, this is a very nerve-wracking position. Coming upon Solo Suit and watching their videos, I decided to take a leap since I'm self-represented. The process is very easy and has taken away some of the anxiety. Great, glad we could help you out, Bruce. We got Michael the servant. Excellent service. I'm very impressed with the quality of the service. There we go. Let's see. Very good service, easy to navigate the tools, and just a great customer service. This is from Alfonso. I would love to give a special thank you to Hannah. That's our wonderful assistant here in the chat. Hannah Locklear, just an amazing person, very responsive, and gets it done. There you go. I'll give her a 10 out of 5 stars. Love that. Thanks, Alfonso. You'll see we've helped over 200,000 people now respond to over $1.2 billion in debt lawsuits. All right, those are pretty big numbers. Because it helped a lot of people. All right, so that's the basic rundown. If you want to do this, you just click Get Started. You'll have to enter in your email address and a password, and then you'll tell us what state you're in. And you'll be able to select one of these packages. We'll tell you more information about them down here. And you'll just give us some information about the lawsuit. You'll basically enter in info from the complaint and summons, and then you will Just letting you, let's see. Right, so you will gather information, you enter some info about the complaint and summons, and then you will respond to each paragraph in the complaint and summons. We make that easy. And then you'll make your defense. Those are like any affirmative defenses that you might have, like you were served improperly or you already paid the debt. Then you'll create the response, and then you'll pay us to file the document for you at the end. All right, that is the quick rundown there. And then once people are done with filing the answer document, a lot of them will come out here to our dashboard. I have a lot of answers there, but you can copy this link and post about this on social media if you want. Any of your friends that use this link and then end up using our service, they actually get gift cards for referring people to us. That's a nice way to make a little bit of money. And a lot of people want to settle their debt, so they might come over here and click solo settle. Most people that come to us, once they've responded, they want to settle the lawsuit. So you'll answer some of the same questions, and then you'll make an offer to settle. So you tell us how much you're being sued for, you tell us how much you want to settle for. Then you'll enter into a structured negotiation with the collector. And then once you agree on settlement terms, you'll be able to sign the agreement and send the settlement amount to the collector on our app. All right, you'll also be able to sign up for something called Solo Settle Assist, which is a great option. You'll be able to, it's the same cost as Solo Settle. You'll just pay a portion of the cost up front, and you'll be able to be connected with a law firm that will fully represent you in your case and get the debt entirely settled for you. All right, so that's a big win. A lot of people do that. All right, so there is a rundown on things. Let's go ahead and get into these questions. We got a first question from Calm Relaxation. Looks like it might be a little bit of an update from Calm. Let's take a look at that real quick here. Alrighty, let's see. Calm Relaxation, I would love to have resolved debt in 1 hour. Spent the last 6 months filing court docs. Finally have a date set for oral arguments. A motion to dismiss and MCM's motion for summary judgment. I just need a live event. I'm preparing for oral arguments before June. LOL. Okay. If you have any questions, call them. Just feel free to send those in. Sounds like you're getting ready for oral arguments, like an actual trial before a judge, probably not before a jury, on your case. Hopefully win that one. Most people end up doing. The winning path is usually taking a stance that the collector can't prove that you owe the debt. Right, so in these cases, the burden of proof is on the collector. They have to prove you owe the debt. It's not up to you to prove that you don't owe the debt. It's up to them to prove that you do owe the debt. And poking holes in their kind of process around there can sometimes be a winning strategy. All right. Kim, we got a question from Kim. I got served a summons from CKS Prime Investments LLC suing me for Verve credit card. I don't recognize it or recall having to ask for validation of proof. They said they mailed. What should I do? Okay. So you've been sued for a debt regarding a CKS Prime Investments credit card. You don't recognize the debt. Okay. So basically, how it oftentimes works for most people that come to us, that's the wrong pen tip here. It's not working either. Let's back up. Okay. There we go. So most people come to us after they've received the summons and complaint. Alrighty? Let's just having some iPad excitement here. Okay, I think that's gonna work for us now. Okay, so most people come to us after they get the summons and complaint, and then they're wondering what to do next. Pretty much the answer is almost always going to be file an answer document. Or the answer is an answer. So answer is capital A. Answer document, it's a formal legal document, needs to be formatted properly, needs to follow the right style, the right formatting. It responds to the summons and complaint, every paragraph of them, and then presents your defense to the court. If you don't file an answer, you will automatically lose your case. Doesn't matter if you owe the debt. Doesn't matter if the statute of limitations has expired. If you don't respond with an answer, you will lose your case. In some cases, people are able to settle before filing an answer, but usually you have more leverage to settle after filing an answer. So usually, pretty much in all cases, the next step is to file an answer document. All right, you can do that with our tool called Solo Settle. Solo Suit, which is on our website. You can just generate an answer document in about 15 minutes. Then you pay us to file the document for you in court. And then once you have filed an answer document, the next step for most people that recognize they owe a portion of the debt will want to settle it. So you'll just make an offer to settle. And one of the easiest ways to do that is on our tool called Solo Settle. And then if you want to have a law firm manage the whole process for you, you can use what we call Solo Settle Assist. All right, so that's the quick rundown there. Got a question from Cheryl. I have a summons for a summary judgment. My defense, I was double billed and frauded by the merchant. Should I use your motion to compel arbitration or Solo Settle? Amount in question is $4,200. Good to know. Average amount of debt that people come to us for is usually around $4,700. So you're in good company there. So you're double billed and you're frauded by the merchant. So I guess I wonder if this is, my first question is, was this for a credit card? It was probably for a credit card. Maybe it's for a personal loan or a point of sale loan, I'm not sure. Also, you're saying you have a summons for summary judgment. Summary judgment isn't part of the summons. Usually what will happen is the collector might file a summons and complaint, the person files an answer, and then the collector will file a summary judgment, a motion for summary judgment. All right, so a motion for summary judgment. And what that does is it is a document that asks the judge to grant a summary judgment saying that the plaintiff should win without there even being a trial because the defendant doesn't have a case. And the defendant can file this, also the plaintiff, but if the collector files it, they're the plaintiff and they're asking the judge to rule in their favor. It's a pretty messed up thing. It shouldn't be granted, especially for filing an answer and saying that you don't owe the debt. So if there's a summary judgment, you want to fight against that. It means you've probably already filed an answer. And then a motion to compel arbitration, that can be filed. Generally, people find it best to file it after the answer. Could be filed before, technically, but usually people file it after. And then we call that the MCA, the motion to compel arbitration. It leverages the arbitration clause in your loan agreement, usually in a credit card agreement, against the collector, making it more difficult for them to collect, but mainly by increasing the costs to collect. All right, so that is an option. Sometimes you can use that in addition to settling. You can use that to increase your leverage to settle. It kind of depends. The collector might just see that as really obnoxious and they might increase their cost to settle. They might not want to settle after you file a motion to compel arbitration. Sometimes you can file a motion to compel arbitration and the case just gets dismissed, or you'll be able to settle for less as a result of it. It's hard to say. You really just got to use your judgment there. and play your cards right. But definitely people can use it to leverage a lower settlement. So you can actually use them both. Some people will file a motion to compel arbitration and then wait a while, see if the case just gets dismissed because the collector doesn't want to pursue it. If it doesn't, they might make an offer to settle. Other people just want to settle right now, so they'll make an offer to settle right now without even worrying about the MCA. So those are some options that you have before you. All right, we got a question from Shu. Hello. My debt got validated by the collector bank. What should I do next? All right. So usually debt validation happens pre-lawsuit. So just want to make sure this is pre-lawsuit. So how that works is like the collector will send a collections letter, right? And then you will respond with a debt validation letter. And then you have to send that within 30 days of receiving the collection letter. That's requesting that they provide proof that you owe the debt and that they have the right to collect on it. If they are unable to provide that information, then they aren't able to collect on the debt further. There's basically a cease and desist clause in the DVL requiring them to not contact you further unless they provide validation of the debt. Right? So there's that. In this case, the creditor validated the debt. If you're really dealing with the creditor, it's not surprising that they validated the debt. Usually this is most effective or most meaningful against the debt buyer, like Midland Funding bought your debt, and you want to validate that they actually can collect on it. If you're just dealing with Discover Bank, the person that had your credit to begin with, your debt to begin with, it's not terribly surprising that they've been able to validate it. So as far as what to do next, you can always try to settle. So you can try making an offer to settle. Debts actually settle for less before they become a lawsuit. So on average, debts settle for 45% pre-lawsuit, but they settle for 85% post-lawsuit. All right, so if you are able to settle before the lawsuit, you might be able to get a 45% settlement. However, after the lawsuit, once the summons and complaint are served, average settlement is 85%. All right, now with solo suit, average settlement right now with our solo settle product is actually 71%. So it's a good 14% lower than the industry average settlement, according to our numbers. Okay, and it's important to keep in mind that these are averages, but the range in reality is very broad. Right, debts might settle for 0%, they might settle for 110%, depending on what happens in the negotiation. So if they validated the debt and you agree that you owe the debt in some way, I would try to settle it pre-lawsuit. You can do that. We don't have any tools for doing that right now. You can do that by trying to call the collector directly. You'll get onto a low-level debt negotiator on the phone, and then just tell them what you can do. There's a lot of different tips for negotiating. One path that probably would work pretty well, at least it sounds like the easiest path, is just to make an offer and then stick to that offer the entire time. So make an offer for 40% of the debt and then just try to stick to it until they accept it. That's one path. All right, we got another question here from Jose, currently being sued for Capital One. But it is a business card. It's under my name and my LLC. However, they are suing me. I don't know much about law, but is this allowed? All right, Jose, yes, you are asking about something called personal guarantee. All right, personal guarantee. Yeah, so this is legal. So usually with a business loan, like if you have an LLC, you get a business credit card for the LLC. Usually when you sign those documents, you're also signing a personal guarantee. So that means that the creditor, if the LLC goes bankrupt or doesn't have any assets, the creditor can come after your personal assets to pay off the loan. So it's a pretty tough situation. Happens frequently, and it's an important thing. Yeah. So if you have a large business debt, there's probably a personal guarantee in your contract, and they can probably come after you for that debt. You'll want to check, definitely worth your time, to check those documents to see if they actually refer to you as a personal guarantor, if they mention a personal guarantee. In almost no circumstances are debts given to small businesses without a personal guarantee. But sometimes, maybe yours is the case where there is no personal guarantee. So it's worth checking and taking a look at that. All right, another question from Laura. Hello, I filed a debt offer using solo suit, and I just can't figure out how to get to the next step of paying for an attorney to look over the document I made on my account page. Great. Let's see if we can't get to the bottom of that, Laura. So basically, if you want an attorney to review the document, you'll just want to choose the premium package. Okay, so you can choose that here. You can also choose that once you are in the walkthrough. You can choose it here, right? This has the attorney review. If you chose one of these other packages, like the standard, before, and now you want to upgrade to the premium, what you'll want to do is you're in your dashboard, the My Documents page. You can click on one of these answer documents. So let's say your answer document is here that you started. You would click into it, and then you would continue going through these steps. You might be in the generate response step, and you'll continue going into the file step, and then there will be an upsell screen where you can upgrade to the premium package and pay for an attorney to review the documents. Right? So I think that's what you're looking for. That'd be a good choice. Got a question from TH. JV and LLC is supposed to, by definition, limit liability. All right. Sounds like TH was talking to Jose. Jose's question. Jose had that question about the LLC. Yeah, that's a good point, TH. It is supposed to limit liability. It does limit liability in some ways. It doesn't limit really your debt liability, but it does limit your liability in a legal sense, so that if your LLC is out operating and then somebody sues your LLC for some reason, if your LLC let's say your LLC has $1,000 in the bank account, they sue you for $10,000. All they will get is that $1,000 in the LLC's bank account, even if you personally have another $9,000 in your personal bank account. Right? So they, as a result of a lawsuit, people can't come after your personal assets with your LLC. So the LLC is limiting your liability in that sense. All right, we got another question here from Septima, and we're down to the last few minutes here, so I'm going to try to go rapid fire on the rest of these questions. Septima, I just went to the court today for a summons that I was never given the opportunity to request validation of debt. Debt showed up in my credit profile and I disputed, and summons was to court. Okay, so once you get that summons, you just want to file an answer, right? It doesn't, it's too bad you weren't able to request validation. It doesn't really matter at this point. You just got to file an answer document, otherwise you'll lose the lawsuit. Okay. RH asked the question, what would be my best option with a debt of $5,900? Kind of up to you. We let people make their own decisions. A lot of people are going to be doing solo suit, the premium package at that level of debt. You can have an attorney review the document. That's good. If you want to settle, you can use the premium package and then go over and make an offer to settle. It's free to make an offer to settle, and then at the end it's 19% right now of the total amount of the debt, only due upon settlement. What would you, RH followed up, what would you suggest as a good offer? One of the few real indicators we've seen around settlements actually happening on the platform is that accepted offers are within 20% of the final accepted range. So the old idea of like starting low and working up to the middle doesn't really work out on the platform. Usually if somebody wants to, if something's going to settle, it's usually going to be within, the first offer is going to be within 20% of the final range. On average, debts settle for 71%. So if you started off at a 51% offer, that'd be kind of the minimum offer that would put you up in a good spot to settle. All right, so that's the idea there. But really, it seems like most of the time, if debts settle, it's really just 1 or 2 rounds. So also, probably leading with your best offer isn't a bad position. You can also do a payment plan offer as well, where you pay an amount of money over a number of months. All right, another kind of clarifying question from Jose. Can Capital One sue me personally under my name, even if I open the business card with an LLC company? Probably. Yes, they can. We got Kara. I got a letter every now and then from a collector about a debt with a credit card. I sent a verification request, but never heard anything back. Times go by, same things happen, but it'll be now from a new collector. Why do they do this? Yeah, they do this because it's just getting sold to a new collector, and then they try to collect, and it gets sold for a smaller amount to the next collector. I was trying to collect this money, trying to make money. If you want to stop this, you can try settling the debt, right? So you can, offering sending a verification letter is a good place to start. Asking them to verify it. If they can't verify it, maybe you don't want to settle, but it means you'll maybe go through this process for a continuing period of time. We got J.R. Hill. What is the difference in the plane? All right, I'm not sure. I'm not sure, J.R. Hill. I'm not sure what plane means here. Sounds like a typo. Don't know. Martha Valadez. Hi, I'm Martha from Nevada. I answered the summons. The lawyer representing the credit card made me an offer. I accepted the offer. Now the lawyer will not respond. Should I call the lawyers? Unfortunately, this is an all too common reality with lawyers where you aren't able to get them on the phone, you aren't able to get them to respond. It depends on the time frame. Oftentimes, lawyers and consumers have a pretty different idea of time frames. The lawyers are probably going to do things at pretty close to the last second because they are totally swamped, right? Lawyers' workloads are enormous and they are super swamped and they're very bogged down by deadlines. So usually lawyers won't be responsive until they really have to be, and then they'll be responsive very quickly and get everything done pretty quickly. So if you're expecting the lawyers to only been a couple days and they haven't responded to you, that's really not a big deal. It regularly takes months for lawyers to get a settlement agreement actually over to you and finalized. If it's been longer than a month, yeah, certainly try calling them. There's some potential that they sent the agreement to the wrong place, like the wrong address, the wrong email, something like that. It doesn't hurt to call them, but also it's really not a bad thing. Like honestly, lawyers manage their time well. Nobody has more deadlines with more intensity than lawyers. So they'll likely get that to you when they need to get it to you. All right. Question from Michael. I made the mistake of ignoring letters from collectors that want a judgment against me in court. It's too late to settle the debt now. If not, what percentage should I offer to settle the debt? It's not too late to settle, even after there's judgment, even after they're garnishing. Collectors are still interested in settling. Once you've lost, they likely aren't going to settle for less than the balance in full of the debt, but they probably will be able to get that onto a payment plan that is going to be less than the amount they will garnish you for. All right, collectors are oftentimes pretty concerned about their image, and they actually do want consumers to have a pretty good experience and like them ultimately. So, yes, they are still willing to settle at this point. Alexandra, I had a case that was dismissed without prejudice. How long can that go, and what other actions can the debt collectors take? Yeah, if it's dismissed without prejudice, they can sue you again. And then even after, if they lose again, they can still try to collect from you, essentially until the end of time, right? So even after the statute of limitations expires, they can't sue you after that, but they can still try to collect from you forever. Heather, until you settle the debt and it's satisfied, effectively. Heather Davis, thank you for your time. How is it possible for debt collectors to sue you on a debt that the original creditor charged off? Yeah, it's a good question. I don't know if there's actually a section in the U.S. Code. I should probably look into that. Hannah, maybe you have an answer on that. I'm not sure. It's definitely legal, no question about it. Debt buying is a very common thing. Basically, the collector just sells the debt to a debt buyer, and then they try to collect from you on it. I know that around the year 2000, laws were passed that made that business model much more common and allowable. Never received the collection letter. This is from Septima. Never received the collection letter. I filed a motion in court. Okay, there you go. All right, folks. We are now 30 minutes after the hour. That's the time where we wrap this up. Thanks for coming on. Glad we could answer some questions for you. Always remember that we are in your court. All right, Solicitude is here to help. We want you to get the best outcomes that you can get on your cases. So we're glad to help you out. We are always in your corner. We're rooting for you. I want you to win. All right. Until next time, you can come back. We do this about once a week. Take care.